Peace, everyone. All right, welcome to Moroccan Post School for International Law, Government and International Law. Welcome. We have a guest speaker today. The day's title of the day's presentation, Jurist and Constitutional Studies, Keng El Bey. I don't see anything, Terrence. All right, y'all. So we have our Keng El Bey will be. This is the second class. We had the class on May 22nd. Due process and contract studies. You can go to Moroccan Post Media YouTube page. That was done on March 22nd of this year. 3 weeks ago. A very good class, due process and contract studies. And we got about almost 600 views on that one. So definitely, we're looking forward to this class today. Before we get started, we want to read the Shema Kaisve statement, also a letter appointing for my appointment, and we have the GoFundMe. All right, looking to raise funds to help us with the trip to the Attica Kingdom Alliance. All right, so on the Attica Kingdom Convention, which be held in September in Atlanta, from September 20th to the 26th in Atlanta, Georgia, and from the 27th through October 1st or 2nd in New York during the United Nations General Assembly. We will be in Atlanta, and also
can't hear on this end.
Who else can't hear me? One person. There's only one person, right? We go upstairs. All right.
I can hear you, man. I can hear you.
All right. To get my books, go to mooresandmasonry.org. mooresandmasonry.org to get my books. Moors and Masonry Part 1, Moors and Masonry Part 2, the Illuminati, Illumination of the Mind, the Masonic Compass Square, the Connection, the Measurement, the Timekeeping. Etymology and vocabulary. We submit you one, and how her Venus and Moon rule. Right? We have, we have our Moroccan Post YouTube. This class will be uploaded on the Moroccan Post YouTube page. Moroccan Post YouTube page. Moroccan Post Media YouTube page. This class will be uploaded tomorrow. If you see here, click, like, and subscribe. Right, so this is the Moroccan Post School for Government International Law. We have our classes uploaded on the YouTube, on our Moroccan Post Media YouTube page. All right, Moors and Masonry Part 2. The Power of Moorish Treaties and the Recovery of Lost Moorish Sovereignty, available now. Go to mooresandmasonry.org. All right, the Moroccan Post School for Government International Law, the international vehicle for the facilitation of the Shem Malachi-based proposal and plan to facilitate political legitimacy, the will of the people, the consent of the people, and good government through education, large-scale community outreach, and networking. The Moroccan Post School for Government International Law's main objective is to facilitate the national political unity of the various Moorish governing body in a Moorish intergovernmental alliance and Central Moorish Imperial Parliament Council. The ultimate goal of the Moorish Intergovernment Alliance would function as a Moorish provincial government, transitional temporary government, to provide international representation and an international voice for our people who, in large numbers, are currently subjugated under an apartheid United States system of legalized slavery, evidenced through the mass denationalization of the original autochthonous, native, aboriginal, indigenous peoples of the land. Furthermore, the provisional transitional Moorish government would facilitate a international law, would facilitate a temporary transitional Moorish government structure to use diplomatic channels and international law to engage in diplomacy with the European nations with which we, the native Moors of the land, have treaties so as to stay in unity with treaties as the law of the land and in honor with international treaties, agreements, covenants, delegations, unions, and conventions of indigenous Aboriginal peoples, people that form the impact with each other, and along with treaties signed with that's supposed to be compact with each other, and along with treaties signed with Great Britain, France, Spain, Portugal, England, Great Britain, Sweden, the Netherlands, Dutch Republic, Belgium, Denmark, Sardinia during the 1500s, 1600s, 1700s, and 1800s, and the joy United States Republic of America in 1787 and 1836 as the ruling power, ruling principle of the norms of law. Sir Malachi Bey's proposal for a call for the restoration of national Moorish political unity through political legitimacy, the will of the people, the consent of the people in good government, education, large-scale community outreach, and network. Sir Malachi Bey's public statement to the people, greeting. My proposal and plan for the restoration of national Moorish political unity is rooted in the past structures of ancient governments. The principle and plan for restoring national political unity among our people, the Moors, most of whom are classified as Black, Negro, colored, African American in the United States Census Bureau, is to facilitate political unity, consent of the people through large-scale community outreach and network. This large-scale outreach approach to unconscious Moors and the network among the conscious Moors having political bodies are vital to contribute to the formation and expression of the will of the people. Having a network vehicle that creates the space for the formation and expression of the will of the people is a fundamental principle to facilitating good government and the basis to political legitimacy. The political action of Moroccan Moorish political bodies coming together to form a central governing body composed of many Moorish bodies to function as a Moorish national, provincial, temporary governing body to serve as the voice of our people in the international arena is much needed to address the systematic generational mass denationalization and subjugation of our people, the Moors, as well as the generational European colonization of our lands, known to the world as North America, South America, Central America, and Americana. An interpolitical constitution will be formed from our Moorish political governing bodies by sending up representatives elected by the Moorish Moroccan people or by supreme authority who will exercise collectively the sovereign power and authority in a provisional temporary capacity that the Moorish Beys, Emirs, Khalifs, Pashas, and Bashals, indigenous Aboriginal people operated in unity with Moorish emperors, sultans, once exercised before the dismantling of our Moorish empire and the usurpation of our Moorish sovereignty due to conquest, subjugation, and colonization by the Empire of Spain, Empire of Portugal, Empire of France, Empire of England, Great Britain, Empire of the Netherlands, Dutch Republic, Empire of Sweden, Denmark, Sardinia, Belgium, and Belgium. When the sovereign power of an empire, kingdom, or nation that ruled over a host of kingdoms or provinces and their temporary domiciles diminished, the people of the empire, kingdom, or nation possessed the inherent and divine right to return to the international law of nations, principles of post-millennium, reversion to sovereignty, recovery of lost sovereignty, self-determination, and autonomy. When Moorish emperors relinquished their sovereign power over the Moorish kingdoms and the territory domiciles they once controlled, we, the Moors, have a right to govern among ourselves and form an interpolitical assembly with an interpolitical constitution that would act or take the place of the sovereign power that the Moroccan Moorish emperors once claimed. The interpolitical constitution will be structured governmental body that will be the structured governmental body that regulates authority over all the Moorish political body politics states by the structured language in the interpolitical instrument. The interpolitical constitution will position us politically to reestablish diplomacy and consular relations with the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of the England, that's Great Britain, Kingdom of the Netherlands, then Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, and Belgium, with which we negotiated treaties during the 15, 16, 17, 1800s. The Moorish treaties proved that the names Morocco and Moor were predominant names that dominated the military engagements, wars, commercial, trading, mercantile, merchant, seafaring, diplomatic, and consular strategies, captivity and ransom strategy of the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of England, Great Britain, Kingdom of the Netherlands, Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, Belgium between the 700s and 1800s. The enforcement of ancient international law principle of restoring a people held against their will to their original condition before being placed into slavery, subjugation, servitude, captivity, and bondage, known as post-millennium, will place our people on the proper road to recover our Moorish lost estates, inheritance, land rights, natural resources, sovereignty, treaty protections, placed in the family of nations, nationality, names, history, languages, genealogy, ancestral festivals, clothing, holidays, rituals, dances, celebrations, ceremonies, philosophy, and the science of healing, with the use of sound and herbs, and the science of astronomy, the law of the stars. The United States Emancipation Proclamation, 1863, 13th Amendment, 1865, 14th Amendment, 1868, and the 15th Amendment, 1870, have been used as political tools to disguise the continuation of slavery, subjugation, and captivity of our people. These United States legislations during the 1860s do not constitute the enforcement of the international law of all nations remedy of restoring and returning a people held against their will under the condition of slavery, subjugation, servitude, captivity, and bondage. Post-millennium is the international law principle of restoring and returning a people to their original condition before captivity, slavery, and subjugation. It is evident that the United States Emancipation Proclamation, 1863, 13th Amendment, 1865, 14th Amendment, 1868, and the 15th Amendment, 1870, have not restored and returned us to our original condition before captivity, slavery, and subjugation. The United States have committed human rights violation by the generations of systematic mass denationalization of our people. The United States does not have a structured foundation set up to rightfully and properly place in a census transmit the natural living being after birth of the indigenous Moroccan Moorish consanguinity in their system of records to protect and safeguard the natural living beings, nationality, and birthrights. The provisional temporary government will allow for the facilitation and formation of the formation and expression of the will of the people and political legitimacy as the path to permanent government and the re-entering the family of nations under the reversion to sovereignty as an old and original state. This political structure will position us politically to effectively address the United States human rights violations by the generations of systematic mass denationalization of our people and the disguising of the continuation of slavery on the Emancipation Proclamation 1863, 13th Amendment 1865, 14th Amendment 1868, and the 15th Amendment of 1870, and the International Community of Nations, Family of Nations. People, used in a political sense, is the repository of the sovereignty of the people and the source of government power. I propose that Shem Malachi Bey, a plan to facilitate the restoration of the exercise of this inherent sovereign power that embodies the collective unity of our people operating in political government structure. It is vitally important to facilitate a political process whereby our people who still remain unconscious and classified as Black, Negro, Colored, and African American in the United States Census Bureau in the Commerce Department can be a part of the will of the people once they become conscious of their Moorish nationality and birthright. a political process that does not facilitate the formation and expression of our people who are unconscious of their Moorish nationality and birthright is not aligned with the principles of political legitimacy, the will of the people, the consent of the people, self-determination, and good government. Moors and Masonry Part 1 is an extensive research and study in the history of Moorish treaties, Moorish engagement wars, captivity and ransoming strategies, diplomacy and consular relations between the Moroccan Empire, including Algiers, Tripoli, and Tunis, and the European kingdoms, Kingdom of Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of England, Great Britain, Kingdom of the Netherlands, Dutch Republic, Kingdom of Sweden, Denmark, Sardinia, and Belgium during the 15, 16, 17, 1800s. Let us reconnect to our ancient knowledge of divine law, the unseen, invisible world, and natural law as expressed by the all-seeing eye by restoring our ancient knowledge of universal law, mentalism, cause and effect, correspondence, polarity, rhythm, gender, opposite, and duality, as well as our ancient knowledge of geometry as the blueprint for creation, as expressed symbolically as the compass and square with the G in the center, and the geometric shapes on stained glass windows of churches, mosques, and synagogues. All right, so next is the Harnessing the Diaspora Current Economic Development Summit, Attica Kingdom Alliance, North America Convention 2023. One, Akibalan, today, tomorrow, forever, September 20th to the 25th, Atlanta, Georgia, September 26th to the 30th, which is we held during the UN, the same time at the United Nations General Assembly in New York. This is the commemorative journal. Contact the Attica Nation Free. Is that Intuga on what's at Attica Nation? I think it's Erie Intunga on Facebook. That's the website, atticakingdom.com. Phone number 413-519 5149 718-864-0103 718-288-6909. Right, Joe?
From the Attica Kingdom Alliance, April 12, 2023. Dua Nicha, Your Excellencies, Udam Makayar. As Africa Kingdom Alliance Royal Ambassador at Large, this official letter of recommendation is on behalf of Moorish Ambassador of Amexem, Honorable Abdullah El Talib Muzi Bey, Moorish Ambassador, to sit at the table in our discussion of the Moors of Amexem/America with the Attica Kingdom Alliance in the one Akabalan today, tomorrow, forever. Abdullah El Talib Muzi Bey, Moorish representative to the Attica Kingdom Alliance, will serve in a non-political capacity as a liaison to educate the 750 kingdoms that embody the Attica Kingdom Alliance. As a Moorish representative, he will facilitate dialogue on political issues regarding the autochthonous, original, native, and indigenous Moors. The Moors have been classified for generations as Black, Negro, Colored, African American, Indian, Spanish, Latino, and Hispanic on the United States Census and on other official documents used in United States jurisdiction. Abdullah will address the primary issue of mass denationalization of the Moors. He will also educate the Attica Kingdom Alliance on the centuries of European colonization of Moorish lands, mass incarceration, linguistic genocide, medical apartheid, mass imprisonment, subjugation by the Empire of Spain, Empire of Portugal, Kingdom of France, Kingdom of Great Britain, Empire of Netherlands, Denmark, Sardinia, and Belgium from the 1500s to the present, and by the United States from 1789 to the present. Our objectives and goals are aligned with the Attica Kingdom Alliance. This conference is an opportunity to collaborate and establish ongoing working relationships with the Attica Kingdom Alliance to address the above issues and to facilitate liberation for millions of Moors in North America, South America, Central America, and for our sisters and brothers on the continent of Africa. On behalf of the Crown of Attica, Makakuvu Ali El Bey, African Kingdom Alliance Royal Ambassador at Large.
Right, GoFundMe, right up. All right, so this is large scale community education outreach and network. Shem Malachi Bey and Abdullah Il Talib Mosi Bey, the liaisons between the Moors in the Moroccan Empire and the brothers and sisters to the Attica Kingdom Alliance, 700 kingdoms in Africa, have been invited to speak at the 2023 Harnessing the Diaspora Current Economic Development Summit and Attica Kingdom Alliance North American Convention held in Atlanta, Georgia from September 20th to the 25th, and in New York City during the United Nations General Assembly from September 26th to the 30th. The Shem Malachi Bey Plan aligns with the Attica Kingdom Alliance objective in recovering the lost sovereignty, restoring the native people blood right to the land, and ending of centuries of European colonization of
Abdullah, you mute.
Shem called me. Can you hear me? Can you hear me?
Yes.
Loud and
All right,
clear.
Shem called. All right. They will be accompanied by two assistants. Call Shem Terrence. They will be accompanied by two assistants, Josette Il Bey, secretary to Abdullah Bey, and the secretary to the Moroccan Post School for Government International Law, will be responsible for taking notes, posting pictures on Facebook Live, and written reports. Terrence Bey, the administrator of the Moroccan Post School for Government and International Law, will be responsible for transportation, video, and photography. Will also give live up-to-date reports on Facebook Live and YouTube. Our purpose is to restore the lost Moorish sovereignty by promoting Shem Malachi Bey's proposal, which is to restore national political unity to conscious and unconscious Moors, most of whom are classified as Black, Negro, Colored, and African American in the United States Census Bureau and on all official documents. This is to facilitate political legitimacy, free will of the people, and consent of the people through large-scale education, community outreach, and network. In addition, the funds will be used to build a legal library to include international law books, political science, political philosophy, political and economic infrastructure books. We are writing to request your assistance in reaching our goal of raising $8,000 by August 15th, 2023. Your donations will position us to address the following issues at the Attica Kingdom Alliance North American Convention: generations of mass denationalization of our people, European colonization of our land, and linguistic genocide perpetrated against the Moors for centuries. Furthermore, the plan will facilitate the formation and expression of the free will, consent of our people, and educate unconscious Moors about their Moorish nationality, blood ties to the land, history, and culture. Your kindness will give hope to many individuals and families as we restore our presence in the international platform. Thank you in advance for your consideration, and we hope that we can count on your support to advance our cause. All right, Joe's going to put the GoFundMe link in the chat. All right, so I want to thank y'all. Thank you for giving your attention and reading this. Right, this will also be read at the beginning of all our classes. Right, so as we promote the Shem Malachi Bey's plan and proposal, and as also as we work to raise funds so we can reach our goal in attending the Attica Kingdom Alliance in Atlanta, Atlanta, Georgia, and also New York. All right. So I present to you Keng El Bey, jurist. That once again, today's lesson will be on jurist and constitution. All right.
Hello.
So, Momin,
Hello, everyone, and good evening. I would like to introduce a friend who stopped by. His name is Keith. They call him El Perro. He got a YouTube channel. He has a Facebook. I will advise you to check out his work. They call him Word Wizard. I would have let him speak, but he had to go for a second to give y'all some insight a little bit before I got started. He showed up, but we're going to get into this. Maymoon, are you ready?
Yes, I'm ready.
Okay, I'm ready when you.
Is my
Okay,
screen sharing?
yeah,
Okay.
I can see it. Constitutional and jurist studies. How to master and achieve the working of jurists through contracts. So what I want you to understand, what is the Constitution and the statutes? What is their relationship? You need to understand the relationship between codes, statutes, and all of these different provisions. They're nothing but extensions of a contractual nature. They're a legal nature between you and these instrumentalities. So when you go to court, this is one of the problems that I see in our community. We don't understand contract law, and we don't know how to express ourselves in a trust relationship to these instrumentalities to get a remedy. So a lot of us are relying on state statutes when all you simply have to do is form a trust in a contractual nature and spell out the breach or the violation in the contract that you have put together. So let's go on, Maymoon. Okay, let me move this out the way. Okay, let me move this down. A juristic person is a non-legal entity that has rights, duties in the same way as a human being. I don't want you to confuse this with a jurist, because the word juristic or jurist is in the word juristic. It can be a social entity, a community, or an association of people, or a firm, partnership, corporation, or other organizations that can sue and be sued in a court of law. It is contrast with a natural person who is a human being. So you got to understand these things when you think about the Constitution. I want you to burn these phrases in your head so that you will understand when you're looking at the Constitution and that you're thinking about these things. I want you to burn these two terms in your mind. Keep these in your mind and your thought at all times. Just dem generis. This is for Latin for of the same kind, right? This is for Latin of the same kind. And what do that mean? That you have to be of the same kind. Why did the United States create you an all caps name? They had to make you a juristic person so that you can be of the same likeness, because two different species of things can't communicate. So they had to create you to be a corporation so then they can say there is no breach in communication. So let's continue. U.S. property. Now I want you to think about this as we go through the juristic, being a jurist and understanding the constitutional studies and the relationship of property rights, because that's how everything is property. A don't care. It's a title. A title is property. Who gave you the title? It's title is property of the institution that gave you that title. Like when you see certain people, they say they are the clerk of court. The state gave them, they'll say the county and the state, and they are the clerk of court of that state. They hold the seat under that title. That title belongs to the state. It's property. The birth certificate, the social security card is property. You are in possession of that property. This is how they are gaining in realm jurisdiction, because you're in possession of these things and it's held in trust. 9/10 of the law is possession, 1/10 is trust. So you're in a trust relationship that gave you instrumentalities, because the United States is an instrument, and they're using instrumentalities in the form of a juristic person to show that you are of the same kind of likeness so they can impose jurisdiction. Let's continue. U.S. property is any right or interest in or to property of any kind whatsoever, whether real, personal, or mixed, whether tangible or intangible. Each case as and while located in the United States include without limitation the capital stock of any person formed and exiting under the laws of the United States or any state or subdivision thereof. I want you to burn this in your mind. When you think about rights, they're telling you it's any right whatsoever of any kind of the United States, either real or personal or mixed, tangible or intangible. That means something that you can touch and things that you can't touch. Okay, let's continue, Maymoon. Key points to being a successful jurist. You got to have good legal knowledge. What that means? You got to be up to date with new laws that's being passed. You have to understand the constitutions, and you have to understand the state laws that you're in. You have to be always up to date to international laws, because you got to understand the United States is a hub for these international powers. They are the principal to the United States, forging a relationship to the United States, as the United States enforce the laws of nations based upon these nations' decision-making within property rights in which the United States govern. So you have to understand how all of these things are infused together to give you a good concept of how to be a good jurist when understanding the data, the information. So when we talk about data or information, we're talking about you being an informant. That means that you are being informed of the information and you collecting the data, which is the evidence, the material evidence, and understanding how to litigate that data, do your collection of evidence and representing to this evidence what they're calling when they say you are on your own recognizance, reminding the court of their duties and obligation under these laws and treaties for enforcement, because they are bound to those obligations. I want y'all to understand that. Analytical skills. You have to be very analytical. You have to be able to sort this information, put it in chronological order. So when you're dealing with the court, they can follow the information. So they can look at this. A lot of Moors, when they, hold on, something happened.
Oh, I was gonna let you know, they're on the next screen as well, if you want to read them from the next screen. The definition, the breakdown of all of these.
Oh, okay.
Yeah. So they can see it as you talk, and everything.
Okay. So communication skills, right? You have to have good communication. I tell everybody is what I use the term effective communication. If you don't know your rights, you don't have no rights. And you have to be able to communicate effectively by understanding your rights as it relates to the relationship that you incur through these contractual nature, creating this legal nature, making you bound. If you don't understand who you are and what you are to the United States, they're not going to explain it for you. Impartiality. You got to understand that the judge has to be impartial. He's a neutral party. He's making a decision based upon fact findings and conclusion of law, which round up to being conclusion of facts and law. Conclusions of facts and conclusions of law. This is the essence of what you're getting to when you're dealing in litigation. Okay, then everybody got to have good integrity. So what do I mean by good integrity? Okay, what happened, Maymoon?
My fault. I don't know what happened.
Okay, good integrity, right? Let's say the both parties, let's say this. If you know, you have information that you know that that can convict somebody. This is why a lot of people can be charged for not reporting crimes, because you have to have good integrity. That's what is required to be a good citizen, to stopping the crime issues, reporting crimes. You know, some cities, all the cities can enforce that, but most of the time they don't. Prosecutors, when they have evidence that exonerates you and they withhold that from the court, that's bad integrity. That's abuse of power, and that is obstruction of justice. That is a violation of their professional conduct when they withhold information that could exonerate you. You got to also have good skills in decision making. You got to understand what you're doing as a great litigator. You got to understand this. So when I teach people or educate people about being a jurist, you must understand the rule of thumb. You are a private investigator. Only argue what you can prove, what the evidence allow you to prove. Personal skills. You have to be able to be personable. When you come into the courtroom, you have to be able to understand how to appear in the court. Make sure your appearance and everything give off a good signal. You got to understand all of these things in the relationship when you're dealing with the court. And you got to keep your emotions in check. You got to have good emotional skills. You got to learn when to object. You got to learn everything. Okay? Okay, legal knowledge. Strong key points and breakdowns, okay? A strong jurist must have a deep understanding of the law. This includes knowledge of the legal system, legal procedures, and legal principles. A good jurist must also stay up to date with changes in the law and new legal developments. Analytical skills. A strong jurist must have strong analytical skills. This includes the ability to analyze and interpret legal text, as well as ability to evaluate evidence, arguments presented in a legal case. Communication skills. A good jurist must have excellent communication skills. This includes the ability to communicate clearly, concisely, both oral and written format. A strong jurist must be able to listen carefully to arguments made by the others and ask appropriate questions. Impartiality. A strong jurist must be impartial and neutral. This means they must be able to set aside personal bias and opinions and make decisions based solely on the law and the facts of the case. Integrity. A good jurist must have high level of integrity. This means they must be honest, ethical, and transparent in all their actions and decisions. Okay, let me move my Okay. Decision-making skills. A strong jurist must have strong decision-making skills. This includes the ability to weigh and balance the competing interests and make sound judgments based on the law and the facts of the case. Interpersonal skills. A good jurist must have strong interpersonal skills. This includes ability to work well with others, include colleagues, legal professionals, and the public. A strong jurist must also be able to handle conflicts, disagreements with professionalism and tact. Emotional intelligence. A strong jurist must have emotional intelligence. This means that they must be able to recognize and understand their own emotions and the emotions of others. And good jurists must also be able to manage their own emotions and responsibilities and appropriately to the emotions to the emotions of others. Okay. Could you move my okay, thanks. Introduction. The litigation is the legal process of resolving disputes between parties. Successful litigation is important because it can result in favorable outcomes for clients. The rule out process is a technique used to qualify and disqualify evidence in litigation. Elements of a successful litigation. To be a successful litigator, you need well-planned strategies. What do I mean by well-planned strategy? You must be able to use the discovery process. I created a 5-phase process. It's called, I use 5 phases, family. You have pre-trial. You have pre-trial, pre-trial, trial, post-trial, and the appealing phase. Those are the 5 phases that I created through understanding the stuff as it relates to this being a good jurist. I developed like the rule out process. That's a process that I discovered myself and utilized through understanding various techniques when making certain discoveries based upon contractual natures and utilizing subpoenas to collect data information to be able to then collaterally attack the jurisdiction in criminal and civil matters. Let's continue. Strong evidence is also needed and crucial to support legal arguments. Expert witnesses can provide valuable testimony in litigation successions. A skilled litigator team can also help maximize the chances of success. The rule-out process is an important element of successful litigation. The rule-out process is a method of qualifying and disqualifying evidence. The rule-out process is also ensure the only admissible evidence is presented in the court. So a lot of times they will present information, and if you don't strike it down, they would call it and it would be deemed admissible, but really is not. See, they have to follow the rules of evidence. And a lot of times the court allow prosecutorial misconduct. This is why a lot of times we're losing in court because the system is a gateway for prosecutors and lawyers to utilize to take advantages of non-attorneys. So the system is predicated on a value base of economic support. Most people who don't have the resources can't hire enough of the legal team to overcome the difficulties presented by the opposing party. We don't have that. The jurisdiction that we're in, this banking attorney jurisdiction, this jurisdiction is really made for attorneys. And you're presumed, if you're a business, you are presumed to know that you must have an attorney on deck. You can't do business. That's why corporations must have attorneys represent them. But they'll turn around and allow you to represent yourself in the court, even in a criminal procedure. They will say, you'll tell you you'll have a right to have an attorney. But one of the things that I have discovered through my actions is that when you turn 18, they never gave you due process and equal protection. And why? They never provide you a right to counsel before you enter to any contract. They never provided you with counsel. That is you must nail them to the wall with the equal protection and due process requisite that is mandated. That is a constitutional guarantee. All substantive and procedural due process is a constitutional guarantee that must be provided by the court. If the court do not provide that, everything they did is unjustified. The rule out process is to also ensure the only admissible evidence is presented in court. The rule out process can be used to qualify evidence that support a legal argument and disqualify evidence that weakens it. Come on, Maymoon, to the next slide. Whenever you're ready. Importance of the rule out process in a successful litigation. The rule out process helps ensure that only admissible evidence is presented in a court. A successful rule out process can strengthen a legal argument and enhance credibility. Ineffective rule out, and an effective rule out process can increase the chance of winning the case. Techniques and strategies for effective rule out process. Okay, preparation is the key. So once again, what do I do? So a lot of times, like I'm gonna tell you a situation. I was helping my brother. We went down to the Social Security. They was giving him a hard time about something, just giving you something, right? So we were going back and forth. They gave him their outline of what is required. It was their standard of how they operate on how to obtain a Social Security number. So he was just upset. He was just going through it. Just making a long story short, they were telling him things that wasn't aligned. I said, this ain't what it says. You're telling us things that's not in this document. And you want somebody to follow instructions according to this document, but you're saying things that's not in this document. So the supervisor was being a little bit being stubborn. She was just being combative and hard to deal with. So I asked her, could you get us someone? I said, before we leave, all we looking for is for you to put something in writing to allow us to be able to hold your institution accountable for the things that you're telling us. That's all. We just need something in writing, and we need you to verify some things, and we need some names, and we need people to identify, right? The reason why I want to do that, I want to collect evidence, because these people are acting under the color of law. They have a color of law form that you can utilize against people who are obstructing your rights to contract, your God-given right, in which there are interference under the color of law, and they're acting outside of their scope, reaching beyond their call of duty, violating the rights that was afforded to you and them. Now you can sue for those rights to be restored, making you whole. You have to understand the collection of data or collection of evidence is very crucial. Do not fight with police. Get names, get dates, get times, get people information. Get other people and witnesses who were there. Don't argue, just collect information and come back and blow them out the water. This is what Keng El Bey learned through the process of litigation. I don't argue. I just collect information. And then I put my case together because I know how to litigate. When I know that they're violating rights, guess what the court got to do? They got to make me whole. Why? Because they have violated rights that I should have was afforded by the Constitution and by the laws of that state, in which a police officer or any officer, agent, or whoever under government scope overreached the boundaries of their duties to encroach rights that was given to me by this institution. I understand how to evaluate these things when you're becoming a great jurist. This is critical thinking. This is why when I was going through cases, I hadn't lost a case in over 7 or 8 years. I knew how to litigate. When I walked in, I had all my bullets in the gun. Okay, diligence and attention to details are important. I say this all the time. The devil is in the details. You have to be very detailed in your structure. You got to know how to lay it out and learn how to lay out everything as a jurist where the judge can follow it, where you paint a picture. I tell people all the time, it's not about who's telling the truth. It's about who's telling the better story, who lays it out the best, and who can draw the people's attention to the facts and lay it on them very heavy where you compel them to act in accordance to what you had came to the conclusion of. Understanding this as a good jurist, you swaying the people. You say, hey, this is the conclusion. Look at what I found. And you sway them because you know how to make it so evidentiary that they'll be so compelled by the information that you presented to them, where they have to act and agree with you and work it out in your favor. Expert assistance can be valuable in identifying and evaluating evidence through analysis of evidence is necessary to effectively apply the rule-out process. Legal standards should guide the rule-out process. So a lot of times you guys, like, for example, they like to use drug dogs. A lot of y'all don't even gather the information on drug dogs, how they're being trained. Contact the institutions. Look at the performance of that dog. How many times have that dog found anybody guilty or not guilty? How many times have that dog been used in discovering of drugs or other things? Collection of data. Understanding was the dog sick, understanding the dog medical history. Anything that you can use by digging and prying into information and uncovering the stuff that's been covered up. Looking in the dirt, becoming an anthropologist, going through, digging up soil, finding the bones, the skeletons in the closet through your investigative work, through understanding legal techniques to find such things that you can pinpoint and nail them to the cross. Let's continue. Conclusion, a successful litigation requires a combination of elements, including a strong legal strategy, solid evidence, skilled litigation team. The rule-out process is an important tool that can increase the chances of success. Of effective use of the rule-out process require preparation, diligence, and expert assistance.
Hey, you want to pull up the next one?
Yeah, pull up the next one.
I'm saying you have to put it up on your end.
Okay.
Yeah.
So what are we going into next? Is that the Constitution?
Yes, the Constitution.
Okay, so how do I do that, Maymoon? Do I go to share screen? You gotta allow me to share the screen. And we're gonna get into the constitutional portion of this, because you got to understand what they call the parole evidence rule. And I'm gonna introduce some new things and topics I included personally in this. So before I get started in the Constitution, you have to allow me to share the screen. I don't know if there's Terrence or May Moon. Y'all have to allow me to share the screen.
All right, see if you can do it now.
Let's see. Share the screen. Okay, here we go. So we're gonna talk about due process, right? I want y'all to understand the first element of due process is notice. Okay, they have to give you notice, and it can't be just any kind of notice. It has to be what they call informed consent. See, how they got jurisdiction is through your consent, but you didn't know certain things that you were walking into, becoming a juristic person, being an artificial person that has to do with rights and duties. You didn't understand none of that, right? You didn't understand what a juristic person was. So where did they offer you equal protection of the law? Because everybody have a right to counsel, an attorney. That's a constitutional right. Where was your attorney before you signed any of these contracts to enter into the United States? Because everything is a contractual matter, and they're practicing legalese, meaning that for the layman, he don't know legality. This is a legal definition of an attorney who is practicing a specific language. A specific language. It's not standard English. And it's only meant for attorneys. And they're holding you accountable to be a part of that contractual business matter without giving you the right to an attorney to make a conscious choice. One of the elements of breach of a contract is conscionability. To be able to make a decision, a wise decision, based upon information that was presented. When did they ever give you a conscious effort to give you informed consent? So in this, it says the court rejects the state's notice of as insufficient, emphasizing the notice must be as one desirous of actual informing the absentee might reasonably adopt to accomplish it. Because of constitutional importance of ensuring proper notice, we're talking about in the form of a proper notice with having informed consent, will not forgive improper notice where a party receives actual notice. See, actual notice is where I just place a notice on your door. Before I could take property, I got to give you an informed notice. Hey, and I got to tell you what the consequences were. Actual notice and informed consent, and informed notice is totally different. And we have to understand the critical elements of being a good jurist if you're going to entertain that world, if you're going to enter to the United States. These are things that you have to be aware of, because you don't have to enter. Your ability to contract and understand the contractual language, the trigger language that's necessary in the contract to safeguard your rights. Having contractual safeguards in every contract. Most of y'all are dependent on UCCs and other things instead of your God-given right, which they say they won't interfere with by the First Amendment, by your contractual nature and protecting your God-given rights to contract in a legal nature that you create in a legal relationship created by you and your God. They have to be expressed. Most people don't know how to contract. When I deal with certain people and I talk to them, have you read your contract? No. When I start reading contracts, I say, man, did you know this was in your contract? Did you know that? Some of the things that people are just not reading, and then they're not understanding what they read. So we got to be careful of contracts that we want to get in. Some of us, yeah, I know you want to buy a house, I know you want to buy a new car, but you're not even qualified to even perform and get those things because you have to be a federal agent. There's certain things that's necessary for you to be in the United States jurisdiction. And most of y'all don't even know that. That is a federal threshold that must be met and qualified in writing. You can dispel the jurisdiction by understanding what is required by state and federal officials to drag you into a courtroom. Let's look at informed consent. Informed consent occurs when there is an agreement to enter action or actions rendered with knowledge of relevant facts, such as a risk involved or any available alternative. You understand this? Very important. Any available alternative. They gotta let you know the alternatives. Informed consent often comes up in the context of legal ethics, medical treatment, and waiver of constitutional rights. I want you to understand this part. I'm not going to go over all of this. You can go to Cornell Law and get some of this, right? So let's look at notice as it was required by due process. Notice, the due process clause of the United States Constitution prohibit courts from hearing a case that could adversely affect the party interest unless the party has been given proper notice. Understand that word proper. You have to be given the right kind of notice, not actual notice, a notice that informs you, that's very informative. To satisfy this notice requirement, notice must be reasonably calculated under the circumstances to inform all interested parties that a lawsuit is pending and it could adversely affect their interests. Even when you're getting in a criminal case, this is why they have to summon you and give you proper notice. Why? So let's go here. So remember what we're talking about. I told you about in realm jurisdiction. So the degree required notice varies depending on the type of jurisdiction that court intends to exercise. To exercise in personal jurisdiction and hand over service or process is usually required. Look at these requirements. For in realm actions, which can affect the interests of anyone in the world, the plaintiff usually must inform all known parties of the interest by reasonable, reliable means, and may then inform the rest of the world by notice of publication. That's why a lot of people try to do what? They use copyright protection. They use these copyright protections filed within the United States, informing anyone who uses copyright material is prohibited without the consent of the governing body, which could be you, your trust, LLC, whoever. Purchasing a notice in a local newspaper multiple times over a period of several weeks is, in tricky cases, courts work the plaintiff to identify the best way of meeting notice requirements. Okay? Notice. Notice is very important. Notice is a mere formality, as Supreme Court recently discussed in Jones versus Flower. In Jones versus Flower, a state seized and sold property for unpaid property taxes. A certified letter meant to notify the owner of the impending sale was returned to the state as unclaimed Afterwards, the state made no additional attempt to contact the owner directly. The court rejects that the state's notice as insufficient, emphasizing the notice must be one of desirous of the actual informing the absentee might reasonably adopt to accomplish it. Because of the constitutional importance of ensuring proper notice, courts will not forgive. I want you to understand it. It said it will not forgive improper notice. It's unforgiving. It's unforgiving. Even where a party received actual notice. So let's go over to the Constitution. Maymoon, what parts of the Constitution am I going to discuss first? Let's put it in context.
First you got Article 1, Section 1.
Article 1, Section 1. Let's go on. So when we talk about the Constitution, we got to remember that all statutes, even state constitutions, must align with this contract. This is a trust indenture, right? It is spelling out the rights of those who are in the what they call jurisdiction of this contract. This is why they tell you anything you say and can will be used against you in a court of law. So know your rights and be quiet. Don't say nothing. So let's go over Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Okay. Understanding Congress and the nature within their plenary powers and scope within this Constitution, which is their jurisdiction, defining their role and scope and duties. What else? What section you want me to go over, Maymoon, that I said I was going to go over next?
Okay, you had Article 2, Section 1 as well.
I know.
Well, with Article 1, you got you still on Article 1 is Section 8 and
okay, let me go over
Section 8, 9, and 10.
Okay, let's go over 8, 9, and 10. 8. Okay. Now, it's very important to understand Congress and their delegated powers by this instrument. It says that Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. So whoever in the United States got to do what? Pay the debts of the United States. Understanding that when you understand this instrument, you got to understand what is you're getting yourself into in the contractual legal nature. But all duties, imposts, and excises shall be uniform throughout the jurisdiction. This is why you have the Uniform Law Commission. They make all the laws uniform. Federal statutes, all state statutes, they're uniform, and the Uniform Law Commission creates all the laws. To borrow money on the credit of the United States. Now, when you're a juristic person, when you become a corporate, some type of corporate entity, right? This is what they do. When they gave you a Social Security card, you can, now people can borrow money on the credit of the United States. Hold on, what's up? to regulate commerce with foreign nations among the several states and with Indian tribes. Who are the foreign nations? That is the UN and all the other, not the UN, the EU, I'm sorry. The European powers that they are been entrusted as their trust protector to collect the taxes and do all of this with. And then you have all the other foreign powers under the UN. And among the several states and with Indian tribes. So you have to understand the nature and cause that you're getting in relationship to this jurisdiction. Hold on one second. Apologize, family. It says, okay, to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcy throughout the United States. So they're telling you that they're bankrupt and that they have to create uniform laws, right? On the matter of bankruptcy. So you have to understand what you're signing up for. This is why you should have had, when you turn 18, informed consent. This contract is written in a legal nature which the average person can't understand and read. So you should have had a right of equal protection to an attorney to discuss these issues before you enter to any contract with the United States. To coin money, regulate the value thereof, and of foreign coin and fix standards of weights and measures, to provide for the punishment of counterfeiting the securities and current coin of the United States. So a lot of y'all get into a mortgage and y'all give them a security agreement. And y'all not even arguing this, counterfeiting, if it's a counterfeit. Y'all not arguing counterfeiting of securities, which the banks use. Is it a counterfeit? Or what do counterfeiting mean as it relates to the jurisdiction, as it relates to rules and responsibilities? Okay, to establish post offices and post roads, to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive rights to their respective writings and discoveries. So what do that mean? This is why a lot of people say, hey, I'm going to write books. I'm going to copyright my name. I'm going to trademark my stuff. I'm going to utilize all of the things to secure my rights, because you're going to have a limited time. They don't want to give you a permanent, because that means you will have a monopoly. So for a limited time, this is why cell phones are always renewed every year. They come out with a new iPhone. This is why cars come out new every year. Every so often they change up the money. Why? Because they're securing their interests and they have exclusive rights in their property and protected by the United States, that's enforced in the United States courts. A lot of us don't know how to operate in trust and in contract law to be able to secure some rights through such mechanisms, through the copyright, United States trademark, to the United States Copyright Trademark Office, securing certain rights, securing certain identities as intellectual property rights through such manner that can be enforced. Such matters could be, such intellectual property can be given to other institutions for exclusive use for a short period of time in return to the creator or the author who allows such grant. Infringement of copyright material. I can teach you so many things about utilizing that copyright material, which is you can create security agreements and other contractual natures, securing certain rights. So when you give certain things to certain institutions like banks, and they're not following the grant, the copyright material that's being followed, and with instructions, they're plagiarizing. They're counterfeiting. You got to understand how to utilize, because I talked about this before. Judges get what they call copyright judgmentship. This is why you have to have a license, because legalese is copywritten. Let's continue. To constitute tribunals inferior to the Supreme Court. So Congress can create tribunals inferior, courts that's inferior to the Supreme Court. So what are they? They're congressional courts. And they're regulated through Congress to define, punish piracy and felonies committed on the high seas. So we're talking about copyright material. Piracies. That could be a felony. The stealing of intellectual property under maritime law. Understanding contracts, how contracts can be intellectual property and published material in other sources that now can be utilized as evidence, and when presenting cases in the courtroom to show by a substantive right and exclusive use of such property, and that such person didn't gain such access by a grant to utilize that, or one has overreached their scope through by not getting full consent and going beyond the consent of the grantor, who gave them clear instructions on how to use such intellectual property rights in this matter. Asking the court to give penalties and fines associated with that under a breach of contract in relationship and under theft of copyright material, plagiarism, and other forms within that you can use by your own hand, by written contractual agreements, by understanding how to contract them. Understanding the rules to the game. To declare war, grant letters of marque and reprisal. What is this? To grant war. When you get a war rent, it's a war rent. They're warring against you. They're saying trading with the enemy act. Grant letters of marques and reprisal. That means that the police officer, they give sheriffs, marshals, police officers the right to seize and take reprisal of property. And make rules concerning captures on land and water. What is this? Maritime. To raise and support armies, but no appropriation of money that you shall be for a longer term than 2 years. To raise and support armies, but no appropriation of money that you shall be for a longer term than 2 years. To provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling forth the militia. I went over this last time. Most of y'all don't know y'all in the militia. The unorganized militia. Look at your state constitutions. It aligns with this federal constitution. To execute the laws of the Union, suppress insurrection, and repel invasion. To provide. So when we talk about, let's talk about this a little bit before I go. So what is the repelling of invasion? So we know that the United States is an instrumentality. We're talking about copyright material associated with a grant by European nations, and they're acting as under the law of agency as an agency for such institution. So what is the invasion? To not allow you to come in and steal intellectual property. To invade and abuse the system. This is why they call people paper terrorists. Let's continue. To provide for organizing, arming, and disciplining the militia. So when you get pulled over, right, and the police say, step out the car. Maymoon, what is it? Force, what is it? Coercion. Do you remember, Maymoon? I'm trying to remember that term. Are you still there? I guess he's not.
I just let him back in. He's coming back in now.
Okay, I'm in.
You remember that term about, what was that called? Coercion, forced coercion. What was that? It was legal to use coercion. What was that term that we went over? I think did I go over that in the last in the last studies? Do you remember, Maymoon? When I was saying
The term for forced coercion. you said?
remember I was telling you that police officers have the right to use coercion?
Yes.
Do you remember that term that was called that we went over?
No, I don't remember the term.
Okay. But just to let
Would
you
that be an
guys know-
offer? Would that be an offer?
No, that's not an offer. It's dealing with you being in the militia. So officers have the right to use coercion to make you obey, because you are in the military by presumption of law through these contractual legal natures that we sign, right? A lot of all the guys are under the selective service. When you signed up for selective services, you are in the military. When you signed up for a driver's license, you are in the military. You just didn't know it. When you hold certain instruments, you didn't know they had military requirements that you were enlisted in the unorganized militia. So now when you hear guys talk about, no, the police can't use coercion. Yes, they can. You are in the military. The military law is different for civilians. If you try to flee the military and they didn't allow you to leave, they will collect you up and they will lock you up. They can use coercion to make you obey the law. You are in the military. You under a military law. So don't listen to nobody talking about the police can't. You can look it up. Me and May, this already, didn't I present that in the last class, Maymoon?
Yeah, you presented that in the last one. We was talking about the Florida Constitution. Well, so yeah.
Yeah, so I presented it. So I guess for those who missed out, go watch it. Go watch it. This ain't what I'm saying. This is with the United States. This is about contracts, family. They whooping us with contracts. You don't understand it. Most of us shouldn't be in the jurisdiction because we don't understand the jurisdiction. Come on, a minute. So, to provide organizing, arming, and disciplining the militia for the governing of such part of them as be employed in the service of the United States, reserving to the states respectively the appointment of officers. Do you see this? Appointments. So when you appointed, a lot of y'all don't know you was appointed. They have to have a written consent, an oath by you granting the appointment. You got to understand this. This is constitutional studies 101. So a lot of times y'all can dispel jurisdiction by understanding this instrument in itself, in its totality. And the authority of training the militia according to the discipline prescribed by Congress. When did you ever get trained? Let's continue. To exercise exclusive legislative in all cases whatsoever over the district not exceeding the 10 square miles as may by session of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislator of the state in which the same shall be. This is where the treaties come in. This is where Abdullah talking about the Treaty of Great Britain. What is it, Abdullah? The Treaty of between United States and Great Britain, the definitive treaty. That's where that comes in, the definitive treaty. You got to start understanding this stuff constitutionally, so now you can connect all the dots for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. And so, purpose of all of these government buildings is for what? The erections of forts, magazines, arsenals, dockyards, and other needful buildings. So they got to have a need for these buildings. So when you see all of these municipalities and all of these state buildings, this is what they're for. The erections of forts, magazines, arsenals, dockyards, and other needful buildings. It's a military base. The United States is comprised of banking and military. You're in a military fort. This is why you're in the militia. See, back in the days, if you look at some of those old movies in the United States, what did they have? They had posts. They had those trees cut around the base, and they had it pointed because those were military bases and people lived in those. Same thing going on today, just without defenses. To make laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. So you got independent departments. So when you see departments, right? But then you see institutions, right? Like the FBI and all of that. They get their delegations from them. They're technically not government. Government, those are private agencies contracted with government to do government work. So the FBI is not a government facility. It is a private institution that's contracted with government. It's a private contractor with being given the rights and duty to exercise certain powers through contracts. Section 9, the migration or importation of such person as many as any of states now existing shall think proper to admit. So here we go again, think proper to admit, due process right to an attorney before you enter the jurisdiction. That's through naturalization. When they naturalize, they get an attorney. Hey, they teach them English. They go through a whole, they watch film, they understand history, they teach them all type of stuff before they can enter the country. Why? That is the admission to get in. Why didn't you get that? Why didn't you, before they subjugated you and made you a subject, a foreign subject, you didn't even get a right to an attorney to get notice. They didn't even give you a notice. Hey, they didn't even give you actual notice. Forget an informed notice. Hey, before you come in, you need to look at this. You have a right to an attorney. Don't sign it. You understand that? You want to waive your rights to an attorney? Let's go. But now they let you come on in without allowing you to sign the contract. They just, before you sign the contract, they never allowed you to even get notice, actual notice of an attorney. It says shall not be prohibited by Congress prior to the year 108, but a tax or duty may be imposed on such importation not exceeding $10 for each person. So a lot of y'all, when they imported you, right, your straw man, you were supposed to only be charged $10. The privilege of a writ of habeas corpus shall not be suspended unless, when the case of rebellion or invasion, the public safety may require it. So we're talking about imminent danger. So you got to understand, the court can say, hey, we're gonna take your property under eminent domain. But one of the things that only could suppress a habeas is when is clear imminent danger. When they're going through a rebellion, a civil war, some kind of invasion of the public space. So this is why you got to understand why they're constantly at war. The war on drugs, the war on education, the war on poverty. They always declaring war. Y'all don't know that there's a silent wars, weapons for silent wars. They're warring against you. You thinking they trying to stop poverty, but they warring against that. That's why they take your kids to truancy, come and get, because your kids ain't been going to school. Why? Because they made a bill to war on education, poverty. They warn. So now you're obligated under these things. They passed the bill. They keep declaring war. Y'all don't even know the wars that they didn't declare within the domestic jurisdiction against the indigenous people. It says no capitation or other direction tax shall be laid unless in proportion to the census or enumeration herein before directed to be taken. No tax or duty shall be laid on articles exported from any state. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another. See this again, they're ports, they're military bases, and that's why you have post offices. It's all military. Over those of another, nor shall vessels bound to or from one state be obligated to enter and clear or pay duties in another. So they're just saying when you're traveling, you ain't got to pay no taxes and pay homage to another state if you pass through, because you are non-resident. You're not a member, okay? No money shall be drawn from the treasury, but in consequences of appropriations made by law and a regular statement and account of receipt and expenditure of all public money shall be published from time to time. Why y'all ain't asking for that? An audit, asking for these things, making sure because they're using your social and they're making money and nobody is don't know how to go about doing this because you don't know how to read this instrument. No title of nobility shall be granted by the United States. And no person holding any office of profit or trust under them shall, without consent of Congress, accept of any presentment, annulment, office, or title of any kind whatever from any king, prince, or foreign state. So they tell you how to expectorate right there. If you do any of this, you don't get the consent of Congress and you accept the title or anything, you just left the jurisdiction. This is how you leave the jurisdiction. Section 10, no state shall enter into any treaty, alliance, or confederation, grant letters of marque reprisal. So the state can't do it. Only Congress can do this. So when you think the police is wrapping you up and doing all of that, they doing it under the order of Congress. The state got to get permission or they can't have a police force. Coin money, emit bills of credit, make anything but gold and silver, coin, tender, in payment of debts. So states can't make any money but other gold and silver. So if you're dealing in the states, so anything that's not doing anything other than gold and silver, it's not in the states. It's in a federal jurisdiction, dealing in intrastate commerce. Pass any bill of attainder, ex post facto law. This is only for the states. I don't want y'all to get confused with the federal government. Those are two different jurisdictions. It says no state shall, or law impairing the obligation of contracts. Here we go again. So most of us don't know how to contract. This is where you get your relief in your contract, not relying on state law. Or grant any title of nobility. No state without the consent of the Congress lay in imposed or duties or imports or exports, except may be absolutely necessary for executing its inspection laws. And the net produce of all duties and imposts laid by any state or imports or exports shall be for the use of the Treasury of the United States. Everything goes back to the Treasury. And all such laws shall be subject to revision and control of Congress. Here we go again. So all the state laws are subjected and revision and control by Congress. States are subjugated, or not subjugated, they have to answer to Congress. This is a contractual nature. You got to look at the legal nature that's just been established by this instrument here. No state without the consent of Congress may lay any duty of tonies, keep troops, or ships of war in a time of peace, enter into any agreement or compact with another state or with a foreign power. So if you're claiming that you're a foreign power, the states cannot get in bed with you. You only can get in bed with the foreign government. I mean, with the federal government. What does that mean? Let's go back to what Abdullah said. As we're talking about setting up consular relationships, setting up provisionary government. Who do you contact? It's not the state. You got to get that through the federal side. or engage in war unless actual invaded or in such imminent danger. Here we go. Imminent danger as will not admit of delay. Clear present danger. Y'all got to understand this, right? May Moon, what's the next article I'm going through? I know I'm going through Article 2. So I'm gonna start off with Article 2. Is you still there, May Moon?
Yeah, after Article 2, Section 1, you have Section 2, 3, and 4.
Okay, let me get into these sections. Article 2, the executive power shall be vested. Understand this, what this word means. It's very important to understand what it means and the relationship in its contractual nature. In a president of the United States of America. Not the United States. It says in a president of the United States of America. So the president, the executive branch, is dealing. So when y'all talk about Article 1 and 2, when we're talking about the rights of America, the president is seated in the rights of America, not the United States. That is Congress. The corporation that y'all dealing with, that is Congress. That's the Article 1 jurisdiction. If you want to deal in the Article 2 jurisdiction seated by the United States of America, that's held by the president in its jurisdiction. Understand the difference between the two. So when you go into these state courts and you're dealing with these inferior tribunals, you're dealing in an Article 1 jurisdiction. They're not Article 2. This is dealing with the enforcement, and they have their own institutions, their own courts, their own everything. And they are enforcing these rights upon you. They're using their enforcement rights. So that's when you're talking about you're looking for the United States, this is where it goes. So if you're trying to argue something under the United States of America, that should be in your caption. And that's directed towards what? The president and under Article 2 jurisdiction. You can't take an Article 1 jurisdiction, which is a corporate matter, into the United States of America, because they each have their own respective jurisdiction. Each one has plenary power over their jurisdiction. That's why you have the checks and balances. One can't override the other. They all have their own jurisdiction. Most of y'all don't know how to argue in court. Y'all don't know. And I'm giving you some of the key points of understanding the constitutionality based upon this instrument right here, dealing in the parole evidence rule. He shall hold his office during the term of 4 years, and together with the vice president chosen for the same term, be elected as follows. Each state shall appoint in each such manner as the legislative thereof may direct a number of electors equal to the whole number of the senators and representatives to which the state may be entitled to the Congress, but no senator or representative or persons holding an office of trust or profit under the United States. Here goes the difference. You see that? It says the United States. So it said, let me hit this point again. But no senator, representative, or person holding an office of trust or profit in the United States, that's the corporation, shall be appointed an elector. Understanding the prospective jurisdiction. Each elector shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves, and shall make a list of proper persons of all persons voted for, of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States. Direct to the president of the Senate. The president of the Senate shall, in the presence of the Senate and House of Representatives, open all certifications, and the vote shall be counted. The person having the greatest number of votes shall be president, if such number may be a majority of the whole number of electors appointed, and if there should be more, one who has such majority have an equal number of votes, then the House of Representatives shall immediately choose the ballot one of them for president. So I want y'all to understand the election responsibility in relationship to what? The democracy. Where is the democracy? It's in the Article 1 jurisdiction. Don't they say they're a democracy? They're enforcing the democracy. They're using a republic form of government as it relates to a democracy. Is a republic form of government in relationship to the contractual nature that Congress have created, or Article 1 jurisdiction, and that you got to understand the venue in which you in, and have it properly titled and specified to argue such within such boundaries and within their jurisdiction. I'm not gonna go through all of this. I want to go through. I want to go to section 2. What did I say? 2, 3, and what? What did I say about Article 2?
You got Article 2, Section 1, and Article yeah, you have Article 2, Section 1, and Section 2, 3, and 4.
Okay, so let's go here. The president shall be commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. Hold on, once again, they see they made this distinction. Why is they making that distinction? Because he runs the what? United States of America. He runs that. So why is he making this distinction? Because he's calling you from one jurisdiction to the other. He may require opinions in writing of the principal officer in each of the executive departments. So we got to understand the Department of Defense, the Department of Commerce, all those various departments, they are directly aligned. You see all those departments, they run everything. I think it's something like 8 or 16 departments or something like that. Then the rest of them is pretty much independent agencies. So a lot of these agencies that you see, they're independent agencies contracted under the Article 2 jurisdiction. They're not technically government, they just got authority, delegated authority from the government to act on the government behalf. They're nothing but private contractors. Upon any subject relating to the duties of their respective office. Who is the subject? You guys are the subjects in your duties. So he controls also the militia. Congress does what? Write up everything in legislative for the militia and controls the militia in a certain capacity in which been delegated to the president through this contractual nature. He can call forth the militia. Congress understand the relationship between each section of government. He shall have the power to grant reprieves and pardons for offenses against the United States. Once again, he can grant you pardons because you're in the militia. You're in the military. You ain't know that. You didn't know you signed up when you got them instruments. You was, man, I'm finna go get my driver's license. Checked off the militia. Thank you. He shall have the, it says, except in cases of impeachment. He can't, when you get impeached, he ain't got nothing to do with that, right? He shall have the power by and with the advice of the consent of Senate to make treaties, provide 2/3 of the senators concur, and shall nominate and by and with the advice of consent of the Senate shall appoint ambassadors, other public ministers, consuls, judges of the Supreme Court, and all other officers of the United States. So the president appoints these people and all other officers of the United States within the jurisdiction. This is all of this stuff is a contractual nature. Delegations of authority, contracts, one contract to another in relationship to the jurisdiction. This is why you have to understand this Constitution to be able to critically assess what's going on. Whose appointment are not herein otherwise provided for, which shall be established by law, but the Congress may by law vest the appointment of such inferior officer, making a big difference. This is the distinction. Inferior officers as they think proper, in the president alone, in the courts of law, or in the heads of departments. I want y'all to digest a little bit. Whose appointments are not herein otherwise provided for, so it's not provided for, and which shall be established by law, but the Congress, here you go Congress, the Congress may by law vest, they got to vest it right, the appointment of such inferior officers as they think proper in the president alone in the courts of law. What is the courts of law? Municipal courts, different stuff, and or in the heads of the department. So Congress can also select inferior officers that's under the executive branch, and they can have officers, right, under an Article 1 jurisdiction to understand how these jurisdictions, how they work in sync. So you got to understand the offices that's created through Congress that sit in conjunction with the executive branch, but they're being controlled by two different jurisdictions, one by the congressional body and one by the executive body. Got to understand these things. It's very important to understand this document. The president shall have the power to fill up all vacancies that may happen during the recess of the Senate by granting commission, which shall expire at the end of the next session. He shall from time to time give Congress information on the Senate of the Union, recommend their consideration and such measures as he shall judge necessary and expedient. He may on extraordinary occasions convene both houses and either of them in a case of disagreement between them with the respect to the time of the adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithful, executed, and shall commission all the officers of the United States. So he commissioned the officers in the corporate jurisdiction. But I want you to understand what he does also. He shall receive ambassadors and other public ministers, right? So this is what Abdullah is talking about, the diplomatic channel of communication. It's through the executive branch, through the United States of America. That's where it sits in Article 2. The corporation rests in Congress. Section 4, the president, vice president, and all civil officers of the United States shall be removed from office on impeachment and conviction of treason, bribery, or other high crimes and misdemeanors. Civil officers, all civil, who is a civil officer? Militia people, y'all civil officers, banks, anybody, they're civil officers because you have what? You dealing in civil, right? You dealing in civil law. Anybody who has to deal in civil law can be deemed a civil officer. Understanding this instrument is very crucial to understanding what you're doing. So I advise a lot of y'all who trying to do all of these processes, stop. Stop. Get yourself hurt. Listening to a lot of people that's very uninformative, trying to get you to deal in instrumentalities that you haven't been delegated the authority to exercise and be able to enforce, and having it have the force of law by not understanding what to do. There's just too many people selling things and they don't understand. They don't even understand this instrument in its totality. Even the important parts that's necessary where they can say, well, I reference the Constitution because the Constitution gave me such grant of authority to exercise such powers. Let's go on to Article 3. It's already 9 o'clock. Judicial, 9:23. The judicial powers of the United States shall be vested in one Supreme Court. In one Supreme Court. So, when you look at those rules of evidence, those rules of the court, the rules of criminal and civil procedure, they wrote this, the Supreme Courts. Everything that under the judicial, right, you have your inferior courts, congressional courts, Article 1, dealing in all of that civil stuff, dealing with that. That's Congress. That's a congressional jurisdiction. But when you look at the rules, they're governed by the Supreme Court. Those are two separate jurisdictions. Statutes and rules are governed by two different institutions within the same body of the Constitution. They come in under two different personalities that have their own vested powers to exercise. So when you don't know how to litigate and you confusing and merging the two, they're going to disqualify you because you're not a qualified jurist, because you don't understand this instrument in totality. And in such inferior courts as Congress may from time to time ordain and establish. what did it say once again? In such inferior courts as Congress may from time to time ordain and establish. So these inferior courts, y'all going into an Article 1 court, not understanding that the rules are governed by a different jurisdiction, and the court, only thing the court is offering you is due process of law. Understanding this, your fate on a statute, arguing all of that. That's why the court, the Supreme Court, look at everything. That's why they say, hey, we ain't got nothing to do with your fate. Your fate was judged. You was judged by the judge and the jury. The jury, the one who decided your fate, the judge did. We just set down the rules. Only thing we have to make sure is they gave you due process and follow the rules. That's the only thing the court is looking, the Supreme Court is going to look at. They're gonna make sure that they follow the legal nature of the contract. They're looking at everything. They don't care about, they don't even care about the contract. They care about the rules. The rules. Understand who is controlling what. As you appeal to those institutions that understand the jurisdiction in which you're arguing based upon the concepts that you're looking at when you're dealing with these two jurisdictions. One is an Article 1, one is an Article 3, and then you got an Article 2. And sometimes they confuse you. They'll use Article 1, Article 2, and they'll say that's an Article 3 jurisdiction, but they're not the same. So you got to be very understanding the nature and the context of what they're talking about through the literature that you're reading. Because they'll take the Article 1 and Article 2 jurisdiction and make it appear as an Article 3 when they're two separate entities that's combining forces that they're utilizing, and they have to give you clear instruction on how the two are operating simultaneously. And you have to understand that or you will be confused. That's why they always say you have a right to an attorney. You have a right. And if you don't know how to ask questions, the attorney, he's only going, if he only can do the best he can at what he know, that's what you stuck with. So let me explain to you this. This is how it works. Poor people get cheap attorneys. Rich people get the best of the best. They have a whole law firm that deals in all areas of law. Poor people get, oh, I'm gonna go get this defense counsel. Rich people have a defense team. Understanding how this stuff works, family. Understanding why Abdullah says community outreach. Why understand we're reaching out. Why we understand we gotta combine forces. Because you gotta understand this instrument right here and how they're using it against you, because you don't understand, because a lot of y'all want to be individuals. Acting as if you are some superhero in the matrix and that you're gonna save everybody. When all we have to do is come together, utilize our forces, stop pretending as individuals, and understand we have to be a united front. All for one, one for all type of psychology to stop the encroachment and birthright theft and all other travesties in our community.
Brother King.
Yes, sir.
Peace, brother. We wanna, can we open up for questions?
Yeah, we can open up for questions.
Let's open up some questions. All right, y'all, this is question time. Raise your hand, please. Raise your hands.
If you want to ask him,
Any points of clarification?
We got Zian Bey.
Sheehan,
Sheehan Bey.
Sheehan, you had the floor, brother.
Yeah, Sheehan.
Peace, brothers and sisters, peace.
All right.
Oh, this seems like it's been forever. Yeah, I just I remember this is more towards our last class in reference to the as far as due process is concerned. And I know that you said that one of the things that when you deal with the Uniform Commercial Code, that that is not the same thing as the Uniform Credit Consumer, what is it, the UCCC?
Yeah,
And so I remember, okay, like a 1099B is for anybody who's holding themselves out to be, or is it? It's a 1099B is for a barter exchange, and a consumer credit transaction is a barter exchange. So if it's a consumer credit transaction and it's in what's the difference between when in that context? What's the difference between the Uniform Consumer Credit and the Uniform Commercial Code as relates to like contracts? Am I making sense, or do I need to?
I kind of understand what you're saying in some context. Let me see if I can take a crack at it. Let me see if I can open you up a little more.
Okay, put it like this: if those are two separate, if they see you as a business operating, if they see you as a business operating in that particular, let's just say generally speaking, they see us as a corporate entity doing business within that jurisdiction.
Okay.
Then, but then in the UCC, it does provide where it says when it gives you the financial statements and what transactions they apply to and who they apply to. So how is it that they are two separate instruments in that sense when the UCC does in fact provide, hey, if there's a 1099, or is that internal? I guess that would be internal revenue. Nonetheless, you're supposed to, it's a barter exchange. A consumer credit transaction will be a barter exchange. So how is that different from based on that rule that the UCC provides, what's the difference between the two?
Okay, the UCCs is for businesses and dealing in commerce. A business is presumed to understand the legality and the legal nature. A consumer, he's not presumed to know the legal nature. He has certain protections. That's why you have consumer protections. He is a protected class within the boundaries of the jurisdiction, within the Article 1. He's a protected person. He has certain rights that are protected. The Constitution only gives you certain protections, but then the statute gives you more protections as a protected person. So as a protected person, you can now make contracts unconscionable based upon certain things they didn't provide you in accordance to substantive and procedural due process, because that's a constitutional guarantee. They have to afford you due process. So you can disarm a contract literally by using the consumer protection laws, saying they were unconscionable in nature due to the fact certain things that they were supposed to inform you of, having an informative consent, right? When you start getting into the IRS,
Full disclosure.
right, full disclosure. When you start getting into the IRS forms and all of that, you are presumed as a business to be a tax expert or have tax experts and lawyers available or on your team. You can't be forgiven like a consumer would. He has certain rights that certain businesses don't have, and vice versa. Did I answer some of your questions?
Yes, I just wanted some clarity. I was thinking about it, and it's like, hey, what's the difference between that? I just try to in our classes, I try to write down questions that I have or things that are not quite meeting up all the way, and so I've been thinking about it, so I just wanted to ask and get some clarity on that. Thank you, brother. I appreciate it.
You're welcome. And for further note, abridge yourself with some of the UCC stuff. go into those states and look at the UCC laws that they have. Abridge yourself with the knowledge of the UCCC, of the Uniform Consumer Credit Codes. Understand how to create contractual natures and establish long-arm jurisdiction or extraterritorial jurisdiction by setting up entities within those particular states that can move around in those other states because it has reciprocity. That's another topic for another class, but once you understand how to move and gravitate to certain information, you will be able to make more ground and leeway by understanding how to contract and utilize trust. Okay. Okay, Yannick, it's on you, my brother.
Yeah, I wanted you to get into more about the trust, how important it is to our community, living in trust,
Well,
protected in trust.
well, if you understand trust law and the degree and dynamics of trust, you can then put in certain provisional and contractual safeguards. You can put in block grants where certain grants are blocked. You can learn how to utilize certain techniques through contracts to ensure the integrity of what's going on when establishing relationships with banks and other legal entities, other juristic persons, by understanding how to protect your community and their interests. And the parties having a vested interest within to that trust where their rights cannot be subjugated because they already protected through contract. And that the trust will be a shield. And then you'll have a trust protector that can then move within the boundaries of the courtroom, showing that they have a vested interest into the court and come in and intercede on that person's behalf based upon the contractual legal nature that have been established. So,
Any
anything else?
any other questions? Any other questions?
Yeah, I got, our sister
Sister Diani.
Deanna. I'll get back to you, Zillion Bang. Give me a
Yeah,
second.
get Sister Diani, yes. Good, sister. You have the floor. You're on mute. You're still muted.
Okay.
All
Islam. Yes, it's Brother Rui and Sister Diani.
Okay,
Yes.
Yeah. My question is pertaining to the Federal Reserve notes behind the word payments. In the Constitution, it says that gold and silver coin is only lawful money.
that's what this, I want you to understand. Hold on, brother, let's clarify, bring clarity. That's only for the states. States can only process gold and silver. That's not for the federal government.
So when Congress authorized the Federal Reserve note, that makes it lawful?
Yes. Yes. The states don't have the power. See, this is how you know if you're dealing with a state institution or a congressional institution, based upon the instruments and the things that specify under the Constitution and which could be exercised.
So the Federal Reserve note at this time is lawful U.S. currency.
It's lawful, yes. Did you want to go back and read?
Wow.
You want to go back and read it? I didn't make this up. This ain't what King El Bey said.
Well, yeah, you can, because we have to show them that. You have to, all right, so we have all right. There's a contention here on the floor. All right, so there's a contention. So you have to support the claim. that the Federal Reserve note is lawful. So we have to show them in the Constitution where that is.
I went over that. I'm trying to make sure I go back. Trying to remember what article I read that. Where is it in? I got. It says no state.
Because a note is a debt.
Article
It's in the
1,
debt.
Section 10. Article 1, Section 10.
Article 1.
Is
Section,
the
okay, Article 1, Section 10. It says no state right here. I didn't make this up. No state shall enter in any treaty, alliance, or confederation, grant letters of marque in reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender or payment of debts. This is a prohibition on the state.
No, there is
State, not the federal.
there's Article 1. There's another article that states that Congress shall not make anything. Congress shall not make anything but gold and silver. There's Article 1.
Section what?
Section 10.
Section 10.
10.
Which you didn't read? Which section did you read? That's not Article 1, Section 10.
This is Article 1, Section 10. This is
That's Article 1, Section 10.
Article 1,
Yes.
Section 10. This is Article 1.
Article 1, Section 4.
Article 1, Section 4. Congress should have the power to coin money. There we go. Congress should have the power to
Yeah.
coin money
Article
Oh, that
1,
was
determine
Section
the
8.
value.
that's called, right.
That's not,
That's Article 1, Section 8. Congress.
Read that.
It's
that.
okay, Congress, it says, okay, Congress shall have the power to lay and collect taxes, duties, imposts, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, and excise shall be uniform throughout the states. Then it goes down to here. Congress to coin money, regulate the value thereof and of foreign coin, and fix standards of weights and measures. Where do you see a prohibition of Federal Reserve notes in anything in this country?
Yeah, but I don't see, but King, we don't also see that is law. I hear what you're saying. We hear what you're saying.
yes.
We show you read that
Let me break
Congress.
it down to you.
Point of
Hold
interest.
on,
Go to
brother,
Article
hold on.
6.
Go ahead, go ahead, Abdullah. I'm gonna break
All
this
right.
down for you.
All right. All right. It doesn't read in there about notes. It reads about coins,
Coin money, right?
coin money,
Right,
determine the values thereof.
right.
It doesn't read anything about Congress having the power to issue notes, to print. The word print's not in there. The word note's not in there. Note's an instrument of debt. So it's not in there. We can't read it into there. We can't read it in there. It's not in there.
Okay, so let me go down here, right?
Point of interest. King,
Yeah,
where does it speak about the tender of payment? Because that's their way, that's how they make the Federal Reserve notes, via tender of payment. They consider a tender of payment.
a tenor, right.
No, they don't.
But
No, they don't.
When you look on the dollar bill.
I made a claim, and I can support it.
All
I
right.
made a claim.
Let me explain to you right here. Let me go here. To establish post offices and post roads, to promote the progress of science and useful arts by securing for the limited times to authors and inventors of this exclusive rights to prospective writings and discoveries.
Can someone pull up a gold certificate in Moors and Masonry Part 1, Part 2? Moors and Masonry Part 2. Moors Masonry Part 2, Shem Malachi Base Chapter. Part 2, Shem Malachi Base Chapter. I have a gold certificate. I have a picture of gold certificate in Moors Shem Malachi Base Chapter, Moors Masonry Part 2, or you can just you can Google. Somebody Google gold certificate. Google gold certificate. See, I want someone to read. Somebody put in the chat gold certificate and read the language on the gold certificate.
Right.
Read the
But,
language.
It's but a
Read-
gold
read the language on the gold
certificate is
certificate.
redeemable by gold. But it's
Yes.
It's going to. All right. That's right. You're going to
Um,
read the language on the gold certificate, and you're going to read the language on a Federal Reserve note. This is how we do this. This is how we do this. This is how the Moroccan Post School for Government International Law. This is how we do this. Somebody pull up gold certificate and Federal Reserve note and read the language at the top, also on the side, and look at notice the difference in the language. We have to do this. Got to do this because we got something on the floor. This is going to be recorded. This is, once again, this is live. It's going to be uploaded. So other people are going to be watching it. So we got to put the evidence on the table, Federal Reserve note and gold certificate.
Point of interest.
Also in Moors and Masonry Part 2, Chapter 2, there was 3 articles I sent out. Yannick, post those 3 articles. Yannick, those 3 articles on gold. The 3 articles, what is the money? What is money? What is money by Aaron Bayera? Aaron Bayera, what is money? And there's another one that's what is money too. It's two what is money articles. Joe, I sent it to you. Yannick, I sent it to you. By series, I sent it to you. Terrence, I sent it to you. Amanda, I sent it to you. I sent you 3 articles. All right. I have those articles, efforts, and Moors and Masonry Part 2 chapter. We got to clear this up. Moors and Masonry Part 2, Shem Malachi Base chapter. There's a case, and one not the Edwin by error. Edwin by error is one of the world leading scholars on monetary. I'm a historian. He's a historian, a monetary historian. He's one of the premier world scholars in monetary history. He wrote an article, What is a Dollar? All right, came across that article in 2014. Sent that out to hundreds of people since then. There's another article that I came across while I was working on Chapter 8, Shem Malachi Base chapter. And it's also called What is a Dollar with a question mark. In that article, there's an 1860 case, 1860 Supreme Court case. Was after 1865 case. The Hepburn, Mr. Hepburn, Mrs. Hepburn owed, get the name, she owed a debt, and the one to whom she owed the debt, he wanted to be paid in lawful money, gold and silver. This is a Supreme Court case. Since that, there's no other Supreme Court case that was of this nature. So this is a Supreme Court case in the 1860s. I have this in Chapter 8 of Moors and Masonry Part 2. So please put those articles, put those articles in there in the chat. All right. And he won his case. He won his case. In fact, the one who designed the greenback, the one who designed the greenback was under Lincoln's administration. He designed it Lincoln later appointed him Supreme Court Justice. He ruled on that case. The very one who ruled on that case, the one who ruled on that case in favor was the one who designed, he ruled against it. The one who designed the greenback ruled against the greenback.
All
as
right.
being
Point
lawful
of
money.
interest. Point of interest.
Hold on, brother, please. We have to, I'm putting out information so people can read for themselves. This is what we do. We're putting
I
out
think-
information,
think we
we're
heard
putting
it.
articles in the chat so people can read for themselves. Put gold certificate
I want to
and
hear.
federal certificate so they can read for themselves. It cannot be Abdullah said, it cannot be King said. We have to move away from that. Just put information out.
We're gonna go to, I'm gonna also go to the IRS manual. Cause I think we're thinking that the dollar is money, it's intellectual property. And
No,
it's-
what, when you say dollar, before, hold on, King, before, because people think a dollar is a piece of paper.
But no, a Federal Reserve.
That's why I had to,
That's
King, that's
serious,
why,
man.
so then let's clear what a dollar is. We can't rush past this, please, we cannot rush past this. A dollar, the etymology of the word dollar, Jacquemstal is the etymology of the word, all right? It's a silver coin. A Jacquemstal is a place in Bohemia where the silver was mined back in the 1500s. So a dollar is not a piece of paper.
All
It's
right,
a
brother.
coin.
Are you done making your point, brother? I don't want to interrupt you.
I'm not done, bro.
Oh my God. Damn.
You are
Please
interrupting.
let us hear.
All right, go ahead, man. Go ahead. I have to provide clarity. We cannot have misconcepts on this venue platform. We cannot have misconcepts on this platform. This is going to go out. This is going to be recorded. This is being recorded and going to be uploaded. So we're going to have a lot of people watching this. We must make sure we provide clarity and proper concepts. All right, you have the floor.
Thank you. Yeah, I was just gonna say real briefly, without being too long-winded, that very simply, right? The gold certificates, the silver certificates back in the days, like 1933 and prior, said that they were redeemable in gold. They were securities that were backed by gold. Now that the gold standard is no longer what it was, these bills that they issue today are not backed by gold. This is why they say on the dollar bill in small print, this note is legal tender for all debts, public and private. So they let people know that this is how we're curing the debts now, public and privately, through this tender of payment called a note. You know what I'm saying? That's simply what I was gonna say.
No,
So
you
now
made
the
a
certificates back in the
misconcept.
days, I didn't make up anything, brother.
Yes,
Look
you,
on,
yes,
you got
yes,
a
you
dollar
did.
bill in your
You
pocket,
said
brother?
dollar bill. There's no such instrument. There's no
Okay, a
such
Federal
instrument.
Reserve note, whatever
No,
you want to
no,
call it, brother.
no,
A
brother,
note.
no, brother,
The
brother,
notes,
brother.
the
It's
notes,
not
the
whatever.
notes,
It's
the
brother,
notes. Okay,
brother,
the
please,
notes.
please,
It
no,
says on
brother,
the
please,
notes. This
brother,
note.
please.
All right, brother. I'm not trying to go through semantics, bro, because I don't need a whole history lesson on
I
semantics.
am.
Let me just finish my point, brother, and you
no,
can
no,
go back to what
no,
you were
I
saying.
am.
So let me just finish my
Yeah.
point, brother, and you can finish your history lesson. All right, so I'm just saying briefly that it says the note. This note, it's a note, okay? Excuse me for saying bill. This note is legal tender for all debts, public and private. So if you want to cure a public debt or a private debt, you can use those notes as a tender of payment. That's a form of payment. Now, is it the proper form of payment? How we supposed to use the silver and gold? We're not running around with gold nuggets anymore. So this is what in this modern day, what is being used, whether it's lawful or not. You could go into the Constitution and see whether it is and decipher all of that, but this is what we're using.
Okay, listen, I'm listening to him. Let me explain something to you as we confer to the jurisdiction. The money is intellectual property. The law followed the property. We talking about contract law. See, the misconception is y'all believing that we're talking about lawful tender of payment. This is their law. The Internal Revenue Service, what happens? A revenuing. You are in a different, listen, the IRS is ran by the Treasury. The Treasury.
Not government.
No, hold on. It's not government. Nobody said it was government. Y'all gotta let me finish. Because you're gonna go in there and get slam dunked. You're gonna go in there and get slam dunked if you don't understand the UCCs. We're talking about an instrument. They dealing in instrumentalities, contracts. They're dealing in, if you look up, I showed y'all, they dealing in judgmentship royalties. It's the dollar bill is, that's just like, I have a contract. The United States have a right to contract under a venue. IRS is a different venue. They are totally different.
Brother,
That's why they call the Internal Revenue Service. You are dealing in contract law. They compelling performance. That's why they give you a remittance coupon to pay your bill. They're not saying, hey, you have to pay. You are in, this is why you got to understand the jurisdiction. You have to understand the jurisdiction based upon the language. You're dealing with someone's intellectual property that they gave value to. You gave it value by the consenting of the contract. We're dealing in contracts. And if you say contracts is not law, then you're gonna go in there and get defeated because contracts make the law. That's
Brother King.
That's why they can't interfere with the obligations of a contract. I didn't make this up.
Brother King.
Yeah.
Also, by there's no money, right? Say if we have 22 ounces of silver, you can create a bond on that certificate, right? And now it becomes binding on all your debt. So if you got a trust set up, you can operate. You don't have to own anything. You just control it and everything.
Right. You're right. This is why you got to
That's what
understand.
I'm saying for protection, for they keep it simple for our people. What's the next step on how to secure their body right now? You know what I'm saying? What they can do right now to secure their body.
What they can do right now, they can come under a trust, and the trust can put all types of provision. It's all about the contractual nature that you create. That's why states can't interfere with obligations of contracts. We're dealing in contracts. There's only 3 aspects you're dealing with: obligations, duties, and exemptions.
Because when you have a surety, they can't touch you.
Right.
That's insurance. They can't touch you.
They can't touch you. You're right about that. But what I'm trying to explain to the masses is we're dealing in contracts. And Congress have the authority to make inferior courts that is granted by congressions, and they have got in bed with certain foreign powers. And why do you think the dollar bill is copyright material?
There's no such instrument, King.
I mean,
there's no such instrument, brother.
Hold on, let's go to, hold on.
Hold on, let me clear this up.
Let me clear it up
because somebody said I was dealing with semantics. Somebody was, hold on, let me clear this up, man, because I'm not gonna have somebody dismiss what I'm saying. I'm dealing with semantics. All right. This is how we get our ass kicked because we don't understand language.
Yes.
All right.
Yes.
So we need to understand etymology and semantics and how they're the basic tool for the manipulation of reality is the manipulation of words. Those who control the meaning of words control the people who must use them. And so they can continue to construct new meanings upon new meanings. There's no such instrument that ever existed called a dollar bill. It doesn't exist. A dollar is a coin. It's not a dollar. That's part of. That's how they're getting us through linguistic genocide. And so when someone like myself, who works in clearing it up by going to etymology, someone like Edwin Vieira is the world leaders, scholar in monetary history, Harvard University. He's a monetary historian. He goes back to the Spanish mill. This was already set. There was all the European, when the United States they formed, they was using a pre-existing coin, the dollar, which is a dollar, which is a coin, silver gold coin, was based off, the value was based off a pre-existing coin, the Spanish mill, which actually is the Moorish mill. So language is important, because what they do is they distort so they can steal our birthright. They can use corruption, deception through language. We must understand. So just dismiss that I'm just dealing with semantics. Understand the difference between semantics and etymology. Etymology deals with the history, origin, the true meaning of words. Semantic deals with how words acquire new meaning over the period of time. And so what they're doing, they can construct new meanings to suppress the original intent. So that quote by Philip K. Dick, once again, the basic tool for the manipulation of reality is the manipulation of words. Those who control the meaning of words control the people who must use them, and that's how they're controlling it. If we don't come to understand how we're being controlled through linguistic genocide and through semantics, through the constructing of new meanings, and the burying suppression of original meaning, concepts, and thoughts. Clarence Thomas, Supreme Court Justice. There's a case that we're dealing with commerce case. Clarence Thomas used a 1792 dictionary, to define the meaning of commerce. He went to an old dictionary. I'm going to send, you know what? We got Terrence, we're going to do a class on this. We're going to do Clarence, and I'm going to have a buku reference upon references. And show I'm going to show y'all how they are using, how the Supreme Court justices do not have a methodology of using dictionary. They just use dictionaries randomly. There's also a case called, Amanda, put this in the chat. The original meaning of the Commerce Clause by Randy Barnett. We're going to arm y'all. Y'all are never going to say Abdullah said anything. The original meaning of Commerce Clause by Randy Barnett. Came across that in 2014. You got everybody ever, what is $1 is another one. All right, so that 1862 case.
So
Brother Abdul, could I just give everyone something to look up? If it's a case that was in 1969, it was a case between the First National Bank and Jerome Daly. The plaintiff was Jerome Daly, and he won a decision in that case, and it all had to do around the Federal Reserve note, because the Federal Reserve note didn't offer consideration. So that's Jerome Daly versus First National Bank, 1969. Federal Reserve notes was void and ruled unconstitutional.
Put that in the chat.
I don't know how to do, I'm not computer literate.
No, we got somebody. We got people, brother. We got people. Let's say it again.
Okay.
So
We got people.
Let's go back to the beginning. Let's go back to the Constitution. Listen to what I'm saying. Y'all gotta hear me out. I keep trying to tell y'all. I've been litigating too long. I know what I'm talking about. Y'all keep talking about Constitution. They're usurping the Constitution. They're usurping. You're not.
King, we know that.
Listen to what I'm Abdullah, please do not cut me off. Please do not cut me off. Let me finish my thoughts so people can understand what I'm saying to them. They're not using the Constitution. They're usurping the Constitution through contract. And what I'm going to tell you is you have to understand contract. Through the United States, they have adopted the IRS rules. You have what they call a fundamental right. The Federal Reserve notes is intellectual property. That's all it is. So when you dealing in, and you keep talking about the Constitution, you're dealing in contract law. The Constitution and equity that is being granted is due process. This is what I know. If you're not talking about due process violation, no, let me finish.
King, we know stuff too, King.
No,
King,
I know
King,
you do.
we know stuff too, King.
Litigate.
So, King, we know stuff too, brother.
No, we
King,
ain't gonna
we
say
know
we
stuff, bro.
No, I get it.
King,
But
King,
I
we know
want
stuff
to
too,
no,
bro.
let
One
me
at a
finish.
time.
Let
One
me
at a time.
finish.
Please.
Order, please.
One at a time.
All I want to do is finish my thought. I don't like that. Let me finish. That's all I'm asking.
Order.
Until you exercise the boundaries of that courtroom, I had done that. When I
We
talk
know
about
stuff
that,
too, King.
I'm not saying
Come
that
on,
you
brother.
don't know
King,
nothing.
King,
I'm
King,
saying to you,
King,
listen
King,
to me.
King,
I'm
King,
doing.
brother. King. Nah, bro. Hold on, bro. King. You're coming across, brother. You're coming across that we don't know stuff, bro.
I'm not saying
the
that
way
you don't know.
across, brother.
I never said you didn't
No.
know
I know. I didn't
anything.
say you. I didn't say that you said that. I didn't say you said that. I didn't say you said that. I'm saying how you coming across, brother. I didn't say you said that.
Listen to what
I
I'm
didn't say you
saying.
said that.
Listen to what I'm
So you
saying.
want King? I didn't say you said that. It's how you
that's all
coming
I'm trying.
across
Listen
that
to
we
what
don't
I'm
know
trying
stuff.
to tell you.
Order.
Oh my God. I'm trying
Order,
to,
please.
everybody trying to communicate. I'm not coming off as nobody understanding nothing. I'm telling you what you talking about UCCs, you talking about instruments, you talking about contract, you talking about trust law. I know what I'm talking about. If you go in there arguing the merits, you're gonna lose. I always deal in constitutional concepts. That's where the Supreme Court rests. They don't care about any of that other stuff, arguing any of them other merits. I don't go in there and do that. If you heard what I said, I always talk about substantive and procedural due process of law. I do not argue the merits. I don't care about if this legal tender, the context or whatever or nothing. Only the Supreme Court, because the jury and the judge decide your fate. Look up the court decision doctrine. I know what I'm talking about. I've been litigated enough to know.
All right, once again, y'all, there is a court case. There's a court case in 1860 case. So I'm referring to cases too. I refer to cases as well. There's an 1860 case that I have in that. What is a dollar? What is a dollar?
You ain't dealing in a dollar. It's a Federal Reserve note.
No, brother. That's the title of the article. The title of the article is what is a dollar?
We're not talking.
It's a case, a Supreme Court case, brother. I'm referring to a case, brother. As you referring to cases, I'm referring to a case as well. This is a Supreme Court case that dealt with greenbacks, as I said before, and he won the case because Mrs. Hepburn wanted to pay in greenbacks, and that they removed the greenback as being unconstitutional and not a payment of debt, and he would won his case, and that gold and silver would be payment. So what they're doing is they're suppressing and using linguistic genocide.
And what I'm saying,
I refer to cases too. That is a.
And what I'm saying, that ain't what I'm arguing. That's what I'm saying. We're talking about two different things. You're talking about one concept. I'm talking about this is the United States Code legal tender, a payment. They said all they doing is compelling obligations and duties. That's the only thing they compelling, performance.
And I'm saying the United States Supreme Court case.
And listen to what I'm saying. They
Brother,
give you, let me finish. This is all I'm trying to get y'all to understand. Because if you don't understand and just what I'm saying, and you go in there arguing certain merits of a case, and you're not looking at the structure under the substance of a form doctrine, they just tell you foreign and gold, silver are not legal tender of payment for a debt because you're in a different venue. You were in a different venue. You're not in a constitutional venue. You in an Article 1 venue associated with a corporation and a compelling performances and duties. Either you have—
we're talking about what they're bound to. What they're bound to is treaties in the Constitution. We can't, brother, we're not your brother.
They bound to treaties.
King.
They bound to treaties, but listen to what I'm saying. Listen to what I'm saying. Listen
King,
to
I'm listening to
hold
what you're
on,
saying,
hold on.
brother. We are listening.
Let me understand. So what I'm trying
We're
to
listening
tell
to you. We're listening to you.
they have international organizations that sit within these boundaries of these jurisdictions. International organizations that has rights, and they have rights. They are corporations and they have rights as a juristic person. And what they're compelling you to do as a banker is to do tenders of payments. It don't have to be in a Federal Reserve note. It can be in a coupon. It can be, which is a form of remittance, and other international bills of exchange. They do not have to engage in silver.
King, we got somebody. We got a question on the floor, man. DuPont. You have a question. DuPont. DuPont.
All right, so
DuPont,
hold on.
you have the floor.
We're going to take a couple questions, and then we're going to have to end for the night because
we're going to end. We're going to take a couple questions. We're going to end.
Islam.
Islam.
Yes.
Islam. I know that particular case that Abdullah is stating, and I knew about that case 10 years ago. So if I'm just making a suggestion, if we can bring the case up, let's go over that case and then go over what we're going over right now, so we get clarity on both issues.
Okay, that's a fair assessment.
I mean, you need to examine the case, because I remember this case.
That's why I'm bringing it up, bro. That's all. I can't
remember the name of the case, but let's go through that case, lay everything on the floor, and grab what we need to grab out of it. That's vital for our people. So with that, I yield the floor, and I appreciate this whole class.
Yeah, that Jerome Daly case serious, man. That's a good case, bro. King, you arguing the wrong thing, bro.
I'm not arguing. Listen.
Hold on, Yannick, hold on. We got a question. No, hold on, Yannick. Hold on. We got a question. We're gonna stay with questions. Who's next? We're gonna stay with the questions. Who's next? Who's next?
I just want to say, put that case in the chat.
I did text it to Brother Abdullah, the First National Bank of Montgomery versus
you texted
Jerome
to me?
Daly.
All right, I got you. I'm on it.
I did text it to you, Islam. Okay.
Yeah, that was a very serious case, and you really have to read it, and you can, it was a real powerful case.
See, when I go to court, I don't even argue the merits. This is what I'm trying to get y'all to understand. I stop them at the tracks. We don't even get into the conversation because the Supreme Court says due process of law, right? It's the hedges of justice system. So if you get to talking about the Federal Reserve notes or anything, I cut all of that off, because what we're dealing is due process. I'm talking about informed consent and jurisdiction. I don't get into the merits. I cut that off at the beginning. I don't deal in those principles. I already know they usurping the Constitution. And if most people don't understand that at the inception of everything, when you're dealing with contract law, if you don't understand the jurisdictional issues and you don't understand, you're gonna have a hard time battling the court. Everything is contract. That's why
we got questions. Stay with questions. Who's next? Who's next? One more question, we'll end. This is the last question, we're gonna end. The last question. No questions. If there's no question, we're gonna end.
All right.
If there's no questions, we're gonna end.
Ask one
we
more
got a question?
I will ask a question of King. He
Yeah.
talked about the due process of law as far as informed consent. Like when you turned 18, you were not given certain information. Can you just speak on that one more time?
Okay, when you come into the jurisdiction, they say they're going to give you equal protection due process of law, right? So what is required by them, everything is done by attorneys at law. You're not an attorney. You should have had a right when given notice by an informed consent, informing you of the jurisdiction you're getting in before you get in it. Because the only thing you're dealing in three concepts is principles of law, is obligations, duties, right? Obligations and duties, and you're dealing in exemptions. So when you're dealing with these matters, if you're going to exemplify yourself from the jurisdiction, you got to know how to contract. This is where the concept come in. I don't deal in those frivolous arguments about concepts and different things, because I already know they're usurping the Constitution. They're gonna tell you that this is, what is you talking about? We're dealing in this contract. The contract is the controlling force.
Once again, they maintain
So you can exempt
control.
I'm just saying, you're saying you can exempt yourself from the court in that contract by proving through a lack of due process, you're not being informed, having informed consent that you were required to have.
Okay, there are federal thresholds, like I did in the last class, there are federal thresholds that they must must meet. They must have a written consent from you, verifying that you are holding some type of office. They must have a written consent through your mission that you're going to perform 50% of your duties to the state. You must be operating in commerce as it relates to the jurisdiction or through their enforcement. I broke it down in the first class. This is why I'm trying to tell you, when we start talking about case law and certain things about certain particularities, I understand that. I done been there. But I'm talking about cutting the snake off at the head by understanding substantive and due process. I don't get into those other areas because I already know how to do a collateral estoppel based upon understanding substantive and procedural due process as it relates to the contractual matter and what's necessary for the court to compel you to even appear in the courtroom. I ain't even getting into all of that. That's what I'm trying to tell you.
But we are.
And that's this is what I'm.
Listen, when there is a misconcept that comes on this school platform, are referring to the Federal Reserve note as lawful instrument, I will speak up and present evidence to counter that. All right, we're not going to allow no misconcept on this platform, period. We will challenge misconcepts.
It's a legal tender. They don't even accept.
It's not lawful.
Exactly, legal, not lawful.
And so,
legal tender, not lawful.
It's
tender.
not. That's what. But the statement was that it's lawful. That's what we were challenging. The statement on the floor was that it's lawful.
So brother, we can easily get past that. That's not something that to like hold on the whole night going over about.
No,
That's
hold on, brother. Hold on,
you could just get past.
Brother, no, we're gonna hold on the whole night because it's very important. Because when you allow one misconcept, brother, that's your position. That's not mine. That's your position.
Yes.
Not mine. My position is to clarify, because if you are not clear on a word, that when that's set as a foundation, when a misconcept
Yes.
of one word is set as a foundation and rooted in your mind.
And
then
that's what you're
that-
building on.
Yes.
So you're building, you can't build on false concepts.
All right, so
That's a major
let's
misconception.
let's just look up the definition of legal and the definition of lawful. Then we won't, when
On
we
the-
understand the
on-
difference, we'll move on.
On the,
Like,
I gave,
really?
I
Matter of fact,
said,
I'll put it in the chat.
the federal, once again, analyze the different language that's on the gold certificate and gold certificate and Federal Reserve note. They use the word lawful on the gold certificate. They use the word legal on Federal Reserve note. All right, we're going to end this. We're going to end. All right, we're going to end. So once again, I want to thank King, because we already know how that we like I said, we do challenge misconcepts. We do challenge misconcepts. We will continue to do that. We reserve our right to challenge misconcepts. We reserve our right. We're not giving that up. We're not giving that up.
I'm not arguing a misconcept. I'm talking about substantive and procedural due process.
No, we were talking about the law. We're talking about the Federal Reserve note being a lawful instrument. That's all.
And what I'm saying to you is they using it as legal tender. They using
No, that's what it wasn't stated that way. It wasn't stated that way.
Hold on. I told a whole class on what judge. Hold on. Let me go to United States Code before we go.
We're talking about a statement that was made on the brother. You can, brother.
But what I'm trying to say, Abdullah, what I'm saying to you as a reference, you got to let people complete their thought, man.
King, you did complete the thought. You completed the thought. You made a statement that the Federal Reserve note is a lawful instrument. You made a complete thought, brother. Come on, bro.
United States Code.
Brother, you made that thought. Everybody heard you. Everybody heard you make that statement.
That's the argument itself, whether it's lawful or unlawful.
That was the right. It was a complete thought.
All right, y'all. It's
And this is recorded, so we can go back.
It's 10
Hey,
to
Terrence,
going on
let's take us home,
10:22.
Terrence. Take us home.
Thank
All
you
right,
for
thank y'all.
playing, Terrence.